of this bill deals with the latter of those issues that I just mentioned, the issue around transparency. Now, I know that my colleagues are going to talk about Clause 42, which deals with the Official Information Act. I want to deal with Clause 43, which deals with the amendments to the Ombudsman's Act, because the original bill as drafted by supposedly Hekia Parata, because the bill is in her name, but in reality by John Banks, would have exempted charter schools from the Ombudsman's Act altogether. There would have been no oversight from the Ombudsman. Now, with a very sensible amendment, I think it was actually an amendment put forward by Tracy Martin from New Zealand First, there was agreement at the Select Committee to extend the jurisdiction of the Ombudsman to cover decisions made by charter schools insofar as they relate to standing down, suspension, expulsion under the Education Act. That is the only jurisdiction that the Ombudsman will have insofar as charter schools are concerned. That is absolutely outrageous. These schools will have enormous control over the lives of young people in New Zealand. They will be entrusted with a great responsibility, and yet that one of the fundamental institutions that we rely on in our democratic system, the Ombudsman, will not have jurisdiction. Now, when this issue was raised at the Select Committee and the officials were questioned as to why the Ombudsman's Act should not apply, they talked about the fact that the Education Review Office would review charter schools, and then they talked about the fact that the Secretary of Education would have oversight. And yet we know, in votes that we have just made in this House, that we have removed the power for the Secretary of Education to intervene even when they know that there are serious problems existing within a charter school. Because I put forward an amendment that would have given the Secretary of Education the power to intervene in cases where there were serious problems within a charter school, and this government voted it down. They voted it down without one member of the House, with the National Party, justifying why they did that. And their heads are down and they don't want to hear about this.
What are they looking at?
Because actually, I don't know what they're looking at, they're very intent on something over there, but actually there's a principle here with regard to the Ombudsman's Act, because the Ombudsman has played, in the very recent history of New Zealand, a very, very important role in dealing with a very serious education matter that was not picked up by the Education Review Office, that was not dealt with by the Ministry of Education, and that was a case of systemic bullying within an existing state school in our state school system. It took an investigation by the Ombudsman to shed light on those very serious matters, and under this bill, under this Clause 43, the Ombudsman will not have the power to do that in relation to charter schools. And that is wrong, because all of the agencies whose job it is to deal with education issues failed to pick up those concerns and failed to deal with them properly. It was the Ombudsman who stepped in and delivered what can only be described as quite a scathing report with regard to bullying at a particular state secondary school that finally dealt with the issue. And to all of the parents and the students and all of the others who were involved in that, that was an enormous relief. It shed light on a situation that had gone on for far too long and that had to be dealt with. If that were to happen in one of these charter schools, there would be no protection. There would be no protection for those students, for the teachers who work there, and for others involved. And that is just so wrong. The Ombudsman deals with a lot more than the Official Information Act and concerns relating to stand-downs and suspensions. What is the jurisdiction of the Ombudsman? The jurisdiction of the Ombudsman, the purpose of having the Ombudsman, is to ensure that New Zealand citizens are treated fairly by their government. And why should charter schools be exempt from that? These are schools that are going to deal with New Zealand children. They are going to have effectively custody of New Zealand children for the time that they are at school, and yet this government is washing its hands of the state's responsibility, Mr. Chair.
Chris Hipkins.
Is washing its hands of the state's responsibility to make sure they are adequately cared for. And one of the safeguards that we have now, in addition to the Education Review Office and all the agencies that deal with education specifically, is the Ombudsman. The Ombudsman has jurisdiction over all matters relating to government decision-making to make sure New Zealanders are treated fairly by their government, to make sure that children in our schools and students in our schools are treated fairly, that their welfare, that their health, that their well-being is protected by the government and by government decision-making. And this very clause, Clause 43 of this bill, exempts charter schools from all of those safeguards, and that is totally and utterly wrong. Charter schools should not be exempt from the accountability mechanisms and the safeguards and protections that state schools have. The government have already voted down amendments that would have meant... Even private schools. That's right, private schools are subject to this, so why shouldn't charter schools be subject to it as well? It is just so wrong on so many levels. The government have voted down measures that we have put forward on the Labour opposition that would protect the welfare of young people attending charter schools, that would make sure that they are taught by people who are qualified for the job that they are there to do. The government voted those down. The amendments that I put forward that would provide further safeguards around making sure that these charter schools are subject to the appropriate levels of accountability have been voted down by this government, and that is wrong. Now, I know that my colleagues are going to talk a lot more about the Official Information Act requirements in this bill around Clause 42. I'm sure they've got plenty of things they want to say about that, in addition to the other consequential amendments that this part makes, which ranges over quite a wide range of legislation, including the Legislation Act, the ACC Act, Births, Deaths and Marriages Act, the Health Act, the Immigration Act, the Income Tax Act, the Local Government Ratings Act and the Official Information Act. But I want to talk about the Official Information Act part very briefly, and I know my colleagues will pick this up. This amendment, Clause 42 of this bill, exempts charter schools from the Official Information Act. It means that they are not going to be subject to public scrutiny. They are going to be charged with caring for the health and welfare of young New Zealanders, and they are not going to be subject to the accountability that every state school is subject to. They're going to receive the same levels of funding as every state school in the country, and yet we are not going to have information about how they operate. Now, why is the government doing that? The government's doing that for one clear reason. They don't want people to know how much these charter schools are taking out of the education system in the form of profits. Because charter schools would be allowed to make a profit, and if they were subject to the Official Information Act, we would know how much profit they are going to make. And this amendment means that we won't know that. The New Zealand taxpayer who pay for these schools will not know that. There are a whole lot of other decisions that charter schools will make regarding the health and welfare of our students that should be subject to the transparency and accountability that state schools are. When it comes to student achievement information, a very, very controversial issue at the moment with regard to data collected by schools in relation to national standards and so forth, the principles that apply to state schools around making that information available under the Official Information Act will not apply to charter schools. They will be exempt from some of the bureaucratic requirements that the government have set on state schools, that this national government have imposed on state schools. There will be two levels of accountability in this education system. One level of accountability for the vast bulk of schools that are public schools that are accountable to the public as they should be, and a whole other level of accountability, a much lesser level of accountability for charter schools that will be profit-making institutions, that will not have elected boards of trustees, that will not be subject to the Ombudsman's Act or the Official Information Act, and that will not have all of the safeguards and protections that we as a parliament put in place to protect the welfare, the health and the educational achievement of the students in our schools. This particular set of amendments are wrong on so many levels. New Zealand students deserve better. This government should be hanging its head in shame about the fact that it is removing the safeguards that protect our young people from this Act. These amendments are wrong. I know my colleagues are going to have a lot to say about them, and we will be strenuously opposing them.
Grant Robertson.
Thank you very much.